Hi, welcome to today's program. My name is Zach McGee. I'm a Senior Vice President and Head of Business and Legal Affairs for Miramax. In my role there, I head up all the distribution and licensing for Miramax films, both in the United States and across the world. Prior to joining Miramax, I was at NBC Universal, where I was an in-house lawyer for a number of years. And before that, I started my career at Davis Polk & Wardwell. I was both in New York and in the Bay Area doing litigation. And prior to starting at Davis Polk, I was a law clerk in the Southern District of New York for the Honorable Michael Mukasey. I'm very pleased today to be joined by Jonathan Gottlieb, my co-presenter. Jonathan is a Senior Vice President of Litigation at Fox Entertainment Group in LA, where he handles all manner of matters, litigation matters related to television, film, digital, pretty much anything that comes down the road for Fox. Prior to joining Fox, Jonathan was a counsel in the appellate and litigation groups at Aiken Gump. He clerked prior to starting his career as a law firm lawyer for the Honorable Roger Minor of the Second Circuit Court of Appeals, and Jonathan has been at Fox since 2004. So both of us together, and I guess collectively, have about 20 years of experience as in-house lawyers at this point. And in that capacity, we've had the opportunity to hire really all manner of outside lawyers, I would say, from some of the largest law firms in the world to sort of smaller regional players. We've certainly worked with the most junior associates to the most senior partners, and also having been on the other side of that at Aiken Gump and Davis Polk, respectively, we have a lot of experience about the process of being a law firm associate, and then now the process of being an in-house lawyer who hires law firm associates. So in today's program, what we plan to focus on is how to teach you to think like a client. Much of what you've learned, certainly in law school and in your sort of law firm training and CLE programs to date, has really been teaching you how to think like a lawyer. This is really how to think like a client, and it's really important to always have that in mind because the clients are the ones that pay the bills. Ultimately, the clients are the ones who are going to make recommendations to the partners at your firm about which associates they want on their matters, and certainly your progression at the firm may in part depend on how your clients view your work. And then certainly if you end up going in-house, it's certainly the view of the in-house lawyers that makes it a big difference in terms of whether they offer you a job. So it's certainly something that you want to have top of mind. And when we were looking at this program and thinking about the issue, we looked around and we saw certainly there's been a lot of writing and programs around teaching lawyers the actual nuts and bolts skills of how to be a lawyer and trying to address what people see as a gap between traditional law school education and readiness for practice. And so you've seen one example in California of a report suggesting that the state bar adopts some competency requirements to make sure that lawyers who are going out into practice are well prepared in certain areas. And it really struck us that as much as these programs are devoted to teaching lawyers problem-solving skills and case management skills and communication skills, all of which are fabulously important, what really wasn't covered much is this notion of client relations, and building good client relations and how to handle clients. So we thought that's another reason that this is a good topical program. So today we're going to be devoted to how to teach you to think like a client, things that you should be doing, things that you shouldn't be doing, to really make sure that your clients love you, that they want to work with you, and of course that they hire you again and again. Before we sort of start today, of course, we have to give the usual disclaimer. Jonathan and I are here speaking for ourselves. He's not speaking for Fox. I'm not speaking for Miramax. These are our own observations, having been both law firm lawyers and in-house lawyers. Now, in terms of the format, we're going to have really just a very casual discussion today. We have a number of topics that we're going to pose questions of each other and share our experiences. So the first one, Jonathan, is what are your expectations of associates when you hire them on a matter, and how can they really add value from your perspective?
Yeah, thanks, Zach. I think that I'm going to start by saying something really obvious, which is when in-house lawyers look to hire outside lawyers, the only thing they want is help. So the big guideline is be helpful. Mm-hmm. And at the first level, you can kind of think of this as 3 levels of ways to be helpful. And I think the most basic level is just don't be wrong. Don't make mistakes.
Don't provide misinformation.
Exactly.
Right?
Because if you think about it, if you get any information from your outside lawyer, you're going to rely on it in some way, whether that's legal information or factual information.
Right.
And if that information is wrong at the outset, you start heading off in the wrong direction. And in that scenario, if you're lucky, you discover the mistake later.
Right.
And if you're unlucky, you don't. So if you're lucky, the worst case scenario is it ends up costing you time and money. Mm-hmm. And if you're unlucky, you end up making a decision or going down a course that might be really bad for your business based on bad information.
And you're relying on it, and in many cases you're communicating, you're adopting and communicating that advice to your internal business clients, and there's really nothing worse than you become part of the mistake, and that's a really bad situation for an in-house lawyer to be in.
Absolutely right. And I think it's okay to say, I don't know. It's much better to say, I don't know, than to give information that turns out not to be correct. Again, whether it's legal or factual, I don't know, but I'll get back to you. Here's what I think I know. I'm about 80% sure about this, but let me confirm and get back to you. It's a way better answer than being less than 100% sure, and allowing your client to proceed based on what turns out to be incorrect information. So first level, don't make mistakes. Second level is think about what the question is and answer around the question. So don't just go and be what I call a fetch and retrieve associate, where here's the question, I'm going to throw the stick, you're going to grab the stick and come back.
Right.
Be the kind of person who's going to communicate what they learn in the course of answering the question and provide that added value back to the client.
Right.
A friend of ours likes to tell a story about the senior partner who sends the junior associate out to get a bottle of wine. He says, I need a 1996 bottle of Cabernet from Napa Valley. So the associate goes down to the wine store, talks to the clerk, comes back, tells the senior partner, sorry, they don't have any 1996 Cabernet from Napa Valley. So the senior partner goes to the second associate and says, same request, can you go get me a bottle of 1996 Cabernet from Napa Valley? The second associate goes downstairs, takes a little bit longer, but comes back to the senior partner and says, they don't have any 1996 Cabernet from Napa Valley, but here's what I learned, that there's a comparable Cabernet from Sonoma County, which is right next door, or 1997 is a much better vintage, and they do have 1997 bottles of Cabernet of the same price point and about what you're looking at. So here I generated a list of alternatives. Even though they don't have the 96 bottle you were looking for, here are some things that might be good substitutes. Which associate would you rather be working with? The one who just narrowly answers the question, or who learns about the question, learns around the question, and was able to give some feedback and alternatives?
Right, and for you, the litigators that are watching this, this is not a deposition, right? I mean, you're not answering only the question asked as narrowly as possible. You really want to be helpful. It goes back to your first point, and which of those two examples is more helpful?
And then the third thing, and you can see that these are sort of cumulative skills. You have to be right. You have to think broadly about and around the question. And then finally, at the top level of associate performance, you have people who, in the course of thinking about the question, start to analyze the question, come up with different alternative courses of action that you might choose based on where you are in the case or the transaction, and be able to give advice, pros and cons, risks and benefits of the various courses of action. And I think at the end of the day, that's the highest level of associate performance that you could expect, and it's the most helpful. And I think, Zach, some of that depends on where someone is at their career, right?
Yeah, absolutely. And to follow on, I think that's great advice. And even as an in-house lawyer, we tend to take that last step even sometimes one more step further, in that you're going to look at various alternatives. Sometimes we will look at something and there'll be a question posed, and we'll say, you know what, there's actually a legal answer to that question, but are we asking the right question? Is that even the right approach? So, that's one of the things that we do is sometimes it's not only developing alternatives to the question you're being asked and thinking through the alternatives, we sometimes change the question because we realize that going down a very narrow legal path is not in the ultimate interest of the company. There's something else going on. But yeah, absolutely. I echo what you said, and I think of it as the transition from most junior associate to sort of most senior associate is the movement from being what I call fungible to being critical. And I'm not knocking very junior associates. We were all very junior associates once, but let's face it, as good as you think you are, as good as we thought we were, you're fungible at your first, second year level. That's why you have litigators cross-training as corporate lawyers and vice versa. You're smart, you went to law school, you're careful, you're a good writer, a good reader. Those are the skills you have, and they can deploy them in whatever way. So essentially grabbing one associate versus another to go read a bunch of documents is a task that anybody can do. As you move in your career, become more senior, you become critical. And this is really the thing that you want to strive for. Become critical by gaining expertise. You learn substantive law, you learn industry knowledge, you do a couple matters for entertainment companies, you come to learn what are the key issues in fair use analysis, what are the key issues in licensing. Then you become valuable, and you move to that level where you are as important as the partner, if not actually more important. I mean, I think we can each think of matters where, my first call is always the senior associate, not necessarily the partner in some cases, because I know it's easier for me to get the senior associate. Honestly, the senior associate's a little cheaper than the partner, right? And usually they're the person who is most sort of boots on the ground and really on it. The partner will come in and out and be handling multiple matters. So I think that's really important, is think of yourself going from just a replaceable member of the team to really a critical team member, where if there's a call, something, you need to be on that call, even more so than the partners. That's what I think you would strive for. Relatedly is really, you start to take ownership of your matters. So, whereas your role as a more junior lawyer, sometimes you're just a stand-in from, for a more senior associate or the partner, and the answer is always going to be, okay, let me check into that, let me get back to you, and that's fine. I mean, as Jonathan said, you want to avoid mistakes. So if you don't know the answer, shouldn't get out ahead of folks. But at some point, you're going to be becoming the person who's taking ownership, and that also means one of the partners I used to work with described it as kind of being the intellectual engine of the matter. You're the one who then becomes the person who's watching the deadlines, thinking strategically about, okay, this has come up. We probably need to make a motion for a protective order, or we need to send discovery out to this new third party, or this other thing. We need to prove this up at trial. I'm using all litigation examples here, but just how are we going to get that evidence? Well, we better go out and take this deposition now. So I think those are really the critical things. Among the critical things as you make that transition from kind of more junior a lawyer to more senior lawyer. Another thing is understanding the business context. So I struggle to come up with any example of either a transactional matter or even a litigation matter where the decision how to ultimately resolve, either close the transaction or not, resolve the litigation or not, turned entirely on who had the better legal position. Right? You think in law school, it's all about trying to figure out, whether the argument is supported by the case law or it isn't. In the real world, it's almost always resolved in context of the overall business context. So even if it's a litigation, if Miramax and Fox got into a tussle, there would be, of course, who's right on the merits, but also we have relationships. We are, buyers and sellers of each other's content. We're co-participants in a larger ecosystem. That would certainly, factor into that kind of analysis. Same thing in the transaction. A lot of times you may have the leverage to crush the other side in a negotiation, but you're going to do repeat business with them. So I think that's an important piece of it as well. So Jonathan, what are some things that associates should be sensitive to when they're working with your organization?
Well, there are a number of things, but one of the things that I think is most important to keep in mind is that you have to keep perspective. So keeping in line with what Zach just said, particularly at senior level, your client's matter should always be the most important thing on your plate, which is to say your client should never know that the matter you're working on for them is not the most important thing on your plate. But the corollary there is not true, which is to say the thing that you're working on may not be the most important thing on your client's plate. Mm-hmm. And there are a couple of implications there. One is you need to give people a lot of lead time. So when there's a critical decision coming ahead, or when there's a document that needs to go out, you have to give the person plenty of lead time so that they can integrate that piece of work in the context of their larger priorities. And even though the thing that you're working on for them is the most important thing for you, it may not be the first or even the fifth or 10th most important thing that's on their plate generally. And inevitably, in the course of any given day for in-house lawyers, there are going to be a handful of things that come up that may or may not be as important as the thing you're working on, but are likely to be much more urgent. Mm-hmm. So if you enable your client to prioritize his or her own time, that's going to work a lot better for you, and it's certainly going to work a lot better for the client. You're going to end up with a better outcome and certainly a better relationship.
I think it's hard to sort of understate that. I mean, our days, you go in thinking it's going to be one thing, you're going to read this draft brief and give comments, and you're going to do this and the other thing. I would say fewer than 20% of the days actually go the way you plan. And and it certainly happens to you at the law firm as well, but I think the big difference is that, let's say two of your matters are blowing up at the same time, at least my experience at the firm was, because it's all for the firm, they can move things around. They can readjust your priorities. Whereas with Jonathan and I, if my head of sales it needs me on X and my head of production needs me on Y, I can't really juggle them as well. I have to be sort of in two places at once or deal with it, and it's really hard for us. So then what happens is that draft brief doesn't get read. And that can be really frustrating for you because maybe you pulled an all-nighter to get that brief to me, on the deadline that you said you would, which is what you need to do. but I may not read it for 3 days, and that's just something you have to realize is going to happen. But it's really important for you to still get it to us on those deadlines so that we can work with our own schedule.
And I think one of the things that is a helpful pointer there is if you're not getting the response you want or need from your client in a timely way, it's perfectly okay to follow up and just to remind people that whatever it is that you need is pending, because the likelihood is they're not ignoring you, they have other priorities. But I think that people would much rather be reminded that a certain deadline's upcoming, or we need to accomplish this task by this date, or else this bad thing is going to happen, than for you to have sent it once or made the one phone call and then let it slide and say, well, it's off my plate, it's on their plate, and it's not my fault.
That's another theme we're going to return to. I should never be chasing you, but you may very well often be chasing me. It's another one of these sort of things that aren't equal in the relationship. We're the ones who are paying the bills, and so we get to have a little bit of a privileged situation there. But if I'm looking for you, you need to be responsive. You need to return my calls or my emails, even if you don't have the answer. At least to return the email and say I'm working on it. I'll get back to you as soon as I can. That we never want to be in a position where I'm chasing even the partners, much less the associates. The other side, you may need to follow up with me multiple times just because I have other priorities, and I'll get to you. And I do appreciate it. I don't find it annoying. You may think, oh, okay, you find it annoying. It's really more, every day I'm trying to figure out what I'm going to handle that day, and it's nice to have the reminder from you right there in my inbox.
Yeah. So another thing, in addition to the idea that the priorities inside may not look the same as they look outside, is that things that may seem simple from the outside may not be so simple on the inside, which is to say, in a litigation context, well, we really need this declaration from this person who has information. And it may be impossible to know the logistical or frankly political complexities of getting that done.
I never understood this as an outside lawyer. I never could understand why a simple custodian of records declaration or something couldn't be obtained in an hour. Now we know, well, it's two people share responsibility for that, picking the person at the right level. You don't want somebody who's, too senior, because in some ways that gives maybe too much, particularly there's going to be a deposition related to this. It opens up a broader area of possible questioning. At the same time, you don't want an inexperienced person necessarily. So there's a lot of strategy and politics, and I never understood that as an outside lawyer, why that wasn't the easiest thing in the world, and now as an in-house lawyer, it's really important. So I think that's a very good example.
So in addition to giving lots of lead time and opportunity for feedback on that, it's helpful to have alternatives, right? If we can't get this declaration from this individual, then here are some possible alternatives, and this is why they're not as good, or this is what we give away from this alternative versus plan A.
Right.
So having fallback positions, having ideas of alternatives about how something might be achieved in the event that something that may seem simple from the outside is a little bit more complicated on the inside than you might think it is.
Right. I agree. The other thing I would say is I was just talking about becoming a leader, of your matter, and so of course there's balance. So as you are becoming more confident, as you're getting to the point where you feel like you know the area of law well enough to give advice on the fly, you don't want to ever get ahead of your partner or your firm, because the worst thing, and Jonathan sort of alluded to this, making mistakes or changing advice. I mean, once you give me an answer about a factual matter or legal matter, it's likely I'm going to communicate that on to my boss and my colleagues internally, and if it turns out that advice is wrong or it has to change, it really reflects poorly on me. Part of everything you want to do is make me look good, right? You're making me look good, then I feel happy with the work you're doing, and that's sort of the way the relationship works. So I think, if you need to get buy-in, know that line of when you are comfortable advising, and then others where you feel like you want to get the buy-in before you do it. The other thing in terms of sensitive areas is, of course, hours billed. And this is, again, something that changes radically from your most junior associates to your more senior. So when you're a junior associate, you don't really think about billing time. You go off, you get an assignment, you go do your work, you bill your hours, and then someone else on the team, either a senior associate or a partner, decides if any of that time is going to be written off or whether it's all billed through, and they decide, well, is this actually adding value or really just training you, and they make that call. As you get more senior, though, the chances that your time is going to be written off by somebody before it goes out the door get sort of smaller and smaller. It just becomes less common to write off stuff unless and until we complain, which happens quite frequently. So my advice as you become more senior is become mindful of how much time you and others on the team are spending on particular projects. And I've loved it when associates have come to me and said, okay, you've asked us to do X. in order to complete X, we're going to have to do the following things. We're going to have to research this, and we're going to have to go and read these depositions and these documents. It's going to take Y amount of time. That seems like a lot to me. I want to make sure that that's what you really want us to do, and this is the work product you want. You want, at the end of the day, a little memo describing it. 90% of the time, if you come to me and you say that, I will probably say, okay, wow, you're right. Let's narrow the mission a little bit. I don't feel like we need to turn that rock over for this purpose, and yes, a short, kind of email summary is what I'm looking for. Then I'll be happy when I get the bill, because it's going to be less, and it's going to be exactly what I want. So you kind of become somebody who can help head off billing problems by having those kinds of conversations up front.
And those kinds of cost-benefit questions really ought to be the client's choice, right? If there are 3 options on the menu of how you're going to approach a question.
Unless the insurer is paying. In this case.
If there are 3 options on how to approach a question,
right,
it ought to be that you tell, here's what you get with option A, which is we spend, X dollars and we get a very thorough answer and we've left no stone unturned, ranging all the way for what we call the quick and dirty answer, where we're not going to spend as much time, but there may be things we're less sure about than if we had extended all of the available resources to figure out the best answer to the question at hand.
And then you covered yourself, because if it ends up there was some case or some document you didn't find because it narrowed the scope, then nobody's going to feel like something that was missed. In terms of, I think you had a point about strategy versus tactics, and that sort of transition. What can you say about that?
Yeah, I think that one of the other reasons why it's really good to learn about your client's business is that there may be circumstances where you could try to win the battle, but at the risk of losing the war. And that's advice you'd rather not give, which is to say, if your client is in the intellectual property industry, as both of our companies are, you probably wouldn't want to make an argument in a given case that, if you were to prevail on that argument, would undermine your client's business. Which is to say that there may be ways to win a given case that your client won't want to pursue, because if you won it that way, it'd be really bad for their business. And it may be that it's good to propose those tactics and allow your client to say, I don't think that the implication of that would be good for our business overall, but at least be sensitive to that and say, when you lead up to it, look, I have this really great argument as to why the other side's copyrights are invalid, and I recognize that if we establish that precedent, it might be bad for you, but here's a narrow way we can make the argument that might not have those implications. And that's the kind of advice that shows not just that you're thinking about the narrow case, but that you understand the overall context in which the case arises and the client's more important strategic imperatives.
Yeah, I'm thinking of an example of a very well-known law firm here who has done a lot of representing of studios in participation cases, and then occasionally they'll represent participants. And I remember at least a couple of examples where, through very aggressive representation of the participants, they made some pretty bad law for the studios on some issues in discovery and some other things. And it really drives home for me the notion that for a firm like that relies a lot on representing studios in those cases, taking those positions without advising that client, who also can be, and not only we are often participants as well as we are studios. That's a part that I want to make sure everybody is clear on. We account to people for our films and television, and then other cases we let others distribute for us, in which we're accounted to. So it's a little bit of that, well, if I really take this position here, that may come back to bite me later. And the best thing is for our outside lawyers to recognize that. And you look, as a second-year associate, you're not going to know that. But as a fifth year, you probably will, because you've been through it a couple times, and you'll say, well, here's a danger area, because if we make this argument here and we win, that could hurt you down the road. So it's exactly what you say.
So Zach, we've been talking a lot in the abstract about the kinds of things that associates can do to better serve their clients. Can you maybe give some specific examples of where an associate's really impressed you in that matter?
Sure. And I'm thinking of a transactional matter. That's primarily what I do now, although I do have litigation matters, and I hire outside counsel for those. So Miramax, we're a film company primarily distributing our films to TV networks and digital platforms throughout the world. So that's our primary business, and that's my primary focus. That's where most of our revenue is generated. That's where my in-house lawyers are focused. But in addition to that, and if you've ever seen a film in a hotel or seen it on an airplane, there's a whole area of licensing of films called generally non-theatrical, which covers things like hotels and airplanes and prisons, oil rigs and prisons and schools and all that stuff. And so how do you license to all those different players throughout the world? It sort of comes down to you sub-distribute, and there are about we have about 10 different parties that we sub-distribute our films to in order to cover that universe of things. And it really isn't something that I have time or in-house resources to handle. Probably the largest of these deals is, on the order of $1 million a year for us. I mean, it's not nothing, but it's not, our big licensing deals. And so what I did is I hired one of our regular outside firms, actually a very large law firm, but I actually had them staff it with a senior associate and a junior associate. And this combination was able to draft and negotiate all 10 of these licenses for me. I was essentially able to offload a kind of insignificant problem, insignificant thicket. The trick is all 10 of these agreements have to kind of work together. You can't license the same rights to two different people in the same territory, so it's really, negotiating with each individual licensee, but making sure the whole puzzle fits together without double licensing anything. So I was able to offload this sort of complicated, thicket of agreements to outside counsel, and then a couple months later, I get back 10 signed agreements. Mm-hmm. My, non-theatrical licensing is done for the next 5 years. And so what was really helpful is the senior associate there did a great job of taking this entire project on and keeping me informed, but not really bothering me at every step. I only wanted to be asked if some licensee was asking for something that wasn't typical or customary, and this associate, having worked for me for a couple years and also having worked in the entertainment industry for a couple more, was really very much aware of what's customary and what isn't. And if someone's asking for X, you really will get that experience of no, that's not market, that's a little crazy. Here's really what here's in every deal, on all of these points, there's usually 1 or 2 or 3 different flavors, right, depending on how much you care about something and how much leverage you have. So she was very good about only coming to me with things that were unusual or that I really needed to weigh in on, updating me kind of on the overall progress, but I didn't have any interest or time to be in the weeds. And the other thing is she used a junior associate to do a lot of the drafting and a lot of the early sort of responding to comments, which kept the bill down. So this is a really good example of somebody who was able to basically take a thorny, kind of annoying problem for me, wrap it up in a bow, give it back to me, and then at the end of the day, the bill was not crazy. It was a fair amount of money for a great work product. So I think that's a good example of how a transactional matter can be handled really well by a combination of a senior associate and a junior one.
Yeah, in the almost decade that I've spent at Fox as an in-house lawyer now, I've had the opportunity to work with a lot of great associates, and I think that one of the things, really the main general thing that distinguishes the ones who stand out from the ones who don't, is their ability to inspire confidence that they've got this, right? And there's no one way that you do that, but it's a collection of things. I mean, I think that there are lots of small tasks that you can perform along the way that communicates to your client your mastery of the matter you're working on. For me, outlines, right? If you're going into a meeting, say, here are the things we want to cover. Is there anything else? Mm-hmm. Sitting in a meeting and taking notes. I have to tell you, there have been instances where I'm sitting in a meeting and there's an associate there and they're just sitting and not taking notes, which makes me wonder whether I'm supposed to be taking notes, right, so that the meeting's documented after the fact and we remember what was discussed.
Right, and you're paying for their time. I mean, what are you doing there? I mean, absolutely.
To-do lists, mm-hmm. Here's where we are. Here are the next things that need to be accomplished. Here are the long-term things that we're aware of that we need to address, but that maybe aren't ripe to be addressed now. Mm-hmm. All the kinds of things that say, we know where the tracks are, we know where the trains are, the ones that have left the station, the ones mm-hmm. that are coming in, and the ones that are about to leave, mm-hmm. and everything's under control. Right. And I think the presence of that allows an in-house lawyer to turn their attention and frankly anxiety in a different direction. Right. And you always want to be the person who is communicating confidence and mastery of the matter that you're handling.
And it's funny because it's not an issue of personality. Everyone, you're not going to change your personality. It's things that you do. It's being organized. It's taking notes. It's having the sort of agenda and the outline. The senior partner or the partner can come in and say, Jonathan, don't worry, I got this. And you're going to trust the partner because you've worked with the partner before, and you're not going to worry that the partner's dropping the ball. For more junior folks, you don't say it, it's showing it. And I think that's really how you can learn it. I remember for me, I was involved in a big pro bono case. It was actually kind of a systemic litigation matter that we were doing pro bono, and I was a very junior associate when I started on that team, and it really gave me a chance to be the one who was calling the meetings, setting the agenda. So that may be a chance for you too, because you're going to have senior associates who are probably going to be playing that role, but maybe there's pro bono opportunities, or you'll grow into this. But anytime you have the chance to kind of be, creating the outlines and setting the agenda, it's really valuable experience.
And one of the really key things to keep in mind here is that it's not really any extra work.
Mm-hmm.
These are the kinds of things that you should be doing anyway to prepare yourself or just to maintain the matter.
Right.
The only extra piece of it is communicating it, right? Thinking that this is something my client would like to see, whether or not they're going to pay close attention to it, just to know that this work is being done. And that overall process of communicating the work product that's going on, even if it's not the most polished thing, and even if it's not 100% thought through, are the kinds of signals you can send to the client that this matter is handled, you don't need to worry about it.
That makes us feel warm and fuzzy, and we like to feel warm and fuzzy and safe, and that we are in good hands. So Jonathan, what are some things that associates might not know about kind of the internal dynamics of either the law department or the company in general? Do you have anything to speak to that?
Yeah, it's funny because one of the things that really struck me when I transitioned from being an outside lawyer to being an in-house lawyer was that I used to think of the client, capital T, capital C, as this monolith, right? You're talking to the client, and what comes out of the client's mouth is the client's position, and you only ever need to talk to the client or hear from the client to know what the client wants.
As if there was someone named Mr. Fox, for example, right? What does Mr. Fox say about this?
Well, it's not the way it works, and that in almost every instance, and I would dare say in every instance, the person that you're talking to directly is not the final decision maker, right? And there may be various constituencies within an organization that person needs to talk to get the answer or the information or the guidance that they need to proceed. And I think that has some really important implications for how you're going to handle the matter.
Yeah. Well, it leads me to sort of one of the things I always talk about is we don't like surprises. So, again, in the realm of making us look good, which makes us happy, not to be surprised. So if, again, you're a litigator and you're defending a deposition of one of my key folks, and I don't happen to be in the deposition because maybe it's in, somewhere outside of, it's in New York and I'm in LA, I should be your first call or your first email if something really bad happens in that deposition, something really good. I don't want to hear about it through one of my colleagues. We really need to know kind of first whether it's good or it's bad. If it's bad, then we need to figure out a plan to react to it because, often my boss is going to hear it. When my boss finds out about it, I'd rather be the one telling him and then, okay, well, here's how we're going to deal with it. So that's, I think, really important. I think another thing, and this is, sort of a little bit of conventional wisdom, many people think, and certainly maybe before I became an in-house lawyer, I might have thought this as well, that in-house lawyers, were not as good or as smart as the law firm lawyers. The reason we left the firm is we couldn't cut it there, or maybe for lifestyle reasons, and now we're in-house in this sort of world where, it's not as intellectually challenging or it's not as interesting as it is at a law firm. And often you perceive it this way because maybe you've spent all this time, drafting a brief, sending it to me, and I don't get back to you on it. Or, we have a call, you send me a legal memo, and I haven't had time to read the memo before the call. So I feel like it looks like I'm unprepared, etc. There are some really bad in-house lawyers. There are some that aren't as smart as others. There are some that are lazy. All those things are true. But in general, in-house lawyers are often really good. And the challenge for us is not that we're lazy or that we're not as smart as you outside lawyers. I mean, we were outside lawyers too. It's the time constraints and the prioritization. So, it may be that we go in today thinking we're going to read your wonderful memo and be completely prepared for the call. But, my boss grabs me or head of sales in some crisis and we have to deal with it. So I think the lesson is don't assume that because we haven't read everything you sent us that we're, lazy or not smart. And I think of it as an opportunity, right? If you've sent me all this wonderful stuff, but I haven't read it. But now we're on the call and we have to make a decision. It's your time to shine, right? You've got 2 minutes to distill for me orally everything that's important about what you sent and really frame up the issue. And then I'm going to say, wow, so-and-so, she's really on it. She, in 2 minutes, she told me everything I need to know. Now we're going to make a decision and we're going to move forward. So don't feel slighted that I didn't read the beautiful memo. See it as an opportunity to educate me or, on the call in real time, and we'll make a decision. I think that's something to think about and to keep your perspective kind of, to keep that as part of the way that you view what we do. If we had infinite hours, we certainly would read everything you send us, but we just don't.
And I think one of the things that is a takeaway from that is know your audience. And I think know your audience in 2 separate ways. The first way is know who you're dealing with, right? If you're dealing with someone who's primarily a transactional lawyer and hasn't dealt with a lot of litigation, then you may need to give some context, even things as basic as, we have to file an answer within X days of the complaint being filed, or else we'll be in default. On the other hand, if you're in a litigation with someone who practiced at a law firm as a litigator, whose job is litigation, you're probably not going to need to explain to them the basic elements of procedure, or what is a deposition. If you're dealing with a copyright lawyer, you're not going to need to start with what the
5 exclusive rights under copyright.
Exactly, or what the requirements are for a work to be copyrighted.
Yeah.
So it's really important to calibrate your advice and your communication to who the person is, in terms of what they know, what they're likely not to know, and what blind spots they might have that are going to prevent you from having effective communication. Similarly, every matter is different. So I think it's really important to establish what your client's expectations are for the extent and form and timing of communications with respect to the matter. So to use the example that Zach talked about a little bit ago about the non-theatrical distribution contracts, he didn't have a lot of time to get into the details of it, and it probably would have been much less effective if the associate he were working with was coming back to him every day or twice a day with questions or decisions to be made about those contracts. On the other hand, I'm sure that there are bigger deals where he's working with outside counsel where he really needs to review every line of every draft of every contract that goes out. And the absence of having the opportunity to do that would also be a big problem.
Yeah, it goes, you mentioned it, you often don't have a good sense of how important your matter is in the grand scheme, but sometimes you do, right? You're working on the company patent litigation, it is the most important thing I'm doing, and that's one where you'd read every word of every letter, every brief, etc. The non-theatrical, again, not important. So I think you shouldn't assume that just because it's the most important thing on your plate that it's important to me, and at the same time, you will, as you do more and more work for the same client, you may get a better feel for it, but it's just about making assumptions, and it's better, as Jonathan says, to have a sort of check-in with the client about how often do you want to be updated on this, what level of kind of communication are you looking for.
And you may be surprised by the answer in either direction. For example, on most of my litigation matters, outside counsel are sometimes surprised that I want to review every document request that goes out.
I definitely don't do that.
Yeah. And depending on the matter, I usually do. So it's a little bit outside of ordinary course. I think a lot of outside lawyers are surprised that their client wants to be involved at that level. But if I don't have that opportunity, there will be a conversation where I say, it's really important to me that we send things out that are consistent with the way we litigate cases, not just to get the information that we want, but to make sure that the whole thing is moving in the right direction, and if and when this ends up in front of the judge, that we're not being perceived as overly aggressive or whatever the bad impression that could result if it's not done correctly to my mind.
Yeah, and I think it's your company in particular, there's certain companies, NBC Universal, where I was a litigator, was the same way, where they handle a lot of cases themselves in-house, and they really pride themselves on being really good in-house litigators and doing a lot of matters themselves. So when you're choosing to send something out, it can be because there's an expertise sort of issue, that there's some different type of a matter, or it's a particularly complex or high dollar or a lot of discovery type of a case, and that's the reason you're sending it out. It's not necessarily that every litigation you send out, no, you generally handle things yourself. So for you as a client, it's really important that the way you litigate, is, even if you're an outside lawyer representing Fox, you want consistency, and you just need to be aware of that. I think, the other thing is, other than expertise, it's often resources that is the reason. Why are we hiring you? Why? It seems to be, in most cases, and unless you're a company that just has, constant litigation, or just you're so massively large that you have to have a massive legal department, General Electric, for example. Fox, maybe you guys have a dozen litigators, across your company, maybe a little more, I don't know. Not even. NBC Universal, probably the same or less. Think about that. So resources is probably the primary reason. You just, you don't want to have 20 lawyers on staff because you're not always going to have enough matters, but then you get a bunch of matters, and that gives you the flexibility to go out. So it's often that you need people, and resources is the reason you're going out. It's not because you're going to defer on expertise or something. So just be aware of why we hire outside counsel, and try to work with your in-house client to make sure you're doing your job in the way that's consistent with how they like to practice.
And the easy way to do that, just again to state the obvious, is have the conversation, right? That first conversation you have where you're learning about the matter, say, how important is this to you? Are there important strategic imperatives that are involved in this case? How involved do you want to be? Do you want to see every piece of correspondence, every email, or are there pieces of this that are going to be left to our discretion? And the client may have a clear answer, he or she may not, but at least identifying the issue and giving the client the opportunity to be involved at the level that he or she wants to be is a big plus.
Right.
Speaking of pluses, Zach, are there minuses, clear pet peeves that people have struck a nerve with you?
Sure. And look, it's I keep distinguishing personality versus what you do. I mean, of course, just like anyone, there are going to be in-house lawyers that you get along better with, that you just are more simpatico in your personality. Hopefully they're people you like to work with and they like working with you in terms of being a good personality fit. But I'm not talking about that. I mean, you all, to get where you are, you've got the ability to communicate well and interact well with people. I guess for me, as you become more senior, one of my pet peeves is just, I think you called it the fetch and retrieve model, or being the yes man or yes woman. Whatever I tell you to do, you just do it. Certainly when you're a junior, that's kind of what I expect. Hey, I need this brief, go get it. That's, but you quickly should evolve from not just if I ask you to do something or I make a statement about something, don't be afraid to challenge me. Now, of course, you're going to have to use your judgment about how you do that, and as you get more senior, and there's a good way to challenge and not another, but I don't always have all the right answers. I mean, I've been practicing for longer than you, probably, but I don't have all the answers, particularly in areas where I'm less familiar. And so if I start going down the wrong path, or I say something that may not always be right, I really do respect people that say, well, okay, I understand, but would you be thought about this? Or, here's another possible thing that could happen, or actually there's a new, California Supreme Court case that just came down. I mean, I'm not, you're probably more up to date than I am on that stuff. My role now is much more transactional. I'm not reading the digests. I'm not, reading the journal. I'm reading the Hollywood Reporter, for God's sake. So if there is a really new development, I may not be the first one to hear about it, certainly. So those sorts of things can be really valuable, and I expect more of that from you as you get more senior.
So one of the ways that manifests in a really concrete way is you may send a brief or a letter to your client, and they may have comments back. And most of the time, I mean, there may be, again, personalities where it's different. Most of the time, the client is not looking to have his or her changes adopted just to gratify their ego.
Right.
They're trying to make the product better, right? And so if they're doing something that, in your view, does not make the product better, it's incumbent on you to tell them that. You shouldn't accept changes uncritically, because in all likelihood, your client is still relying on you that the product's going to be in line with what we need to say, in line with the best way to reach an outcome. And more often than not, the process of giving comments or changes on written product is going to be a process of the client challenging you and saying, what about this? And sometimes it's great, sometimes it's better, but in those instances where it's not, it's your job to tell them why you think it's not.
I'm glad you brought that up, and we could probably spend an hour talking about this, because I just remember my experience, again, as the very junior associate, you send the draft over, whatever the client comments come back, you dutifully put those in and you're done, right? I mean, that's sort of, and now you've got the blessed version that you can send. That transition from just being the word processor to being the one who's like, actually, if we add that reference, we're sort of, leading with our chin a little bit here, strategically that's not a good idea, and you're going to have this, you're probably already managing this tension a little bit now, where, same thing with the partner. I mean, a partner edits your draft, 99 times out of 10, you're going to take the partner's comments, but as you get more senior, you will start to challenge. It's the same concept, you just have to be mindful of it. I'm always reminded of the people that I worked with where, they were such good editors of legal writing. I mean, you write something, you spend so much time, an all-nighter, you write the brief, you think it's perfect, it's as good as you can make it, and somebody comes in and makes it half as long and twice as persuasive. I mean, it's really amazing. We all strive for that, and hopefully, your clients are doing that, making things better. But if they're not making it better, or they're leading with something that you think is not a good idea, you do need to step in and not just be the scribe. So another thing I would say in terms of pet peeves, and I mentioned it briefly earlier, is the notion of non-responsiveness. So if I send you an email or I lob in a call, I really am expecting you to return that promptly. If you don't know the answer to my question, it's fine to say I'm checking on that, I'll get back to you ASAP. It's just not okay for me to be in any sense chasing you. Now the flip side of that is not true. You can chase me, and we all try to be as polite as we can, and try to acknowledge that you've sent me an email and I'm working on it, or I haven't had a chance to look into what you're asking, or I'll return the call. But we all feel, and it's sort of the way the game is played, that we have a little bit of an ability to not respond to you if we don't have time or we don't feel like it, or we just we've got other things on our mind. So don't take it personally, and do continue to follow up with us, because we really want, if it's something important. Let's say you've done a really good job of telling me that okay, we've got to close this transaction by the end of the month because we need to send out an invoice so we can get paid before the end of our fiscal year. So we really need to get the this contract back to the other side. You've sent me your draft markup. You need me to kind of weigh in. If I'm not getting back to you right away, you should be pinging me and more increasingly, with increasing frequency as we get close to that deadline. You've done everything you're supposed to do. It's not okay, just 2 weeks early before the deadline, send it to me once and don't ever follow up with me, because then it's 2 days before we have to close this thing, and I'm going to still think, oh, well, you should have been following up. So it's not, it's not enough to say, well, I sent you an email 2 weeks ago. Yeah, that's helpful, but that's not your only job. I also think, it's always good to keep in mind, we are paying your bills. That's part of the dynamic here, is that you work for us, your firm works for us, so we get to have a little bit of license with, you're kind of on call for me, I'm not necessarily on call for you. Jonathan, anything from your perspective in terms of pet peeves?
Yeah, I think that just to kind of say directly a lot of what we've been talking around for a little while, which is, we recognize that this isn't fair, right? That your job may be a lot harder than ours on a given matter, which is to say, we expect the world from you. You have to be right, you have to be responsive, you have to get back to us quickly, you have to follow up. And from our standpoint, we do what we do, and it's up to us.
It's good to be the king.
But the reality of the situation is that there are a lot of law firms who really want the work,
right?
And there are a lot of people at law firms who would love to do the work. And if you're not servicing the needs that the client has, they're going to find someone else to do it. So there is a higher standard, and unfortunately, this is a situation where, at least in this respect, the customer's always right. So if you're not meeting the customer, the client's expectations, then the client's going to find someone else who can. And I know it's harsh, and I know it's holding you to a higher standard, and I know it's not fair, but that's the job.
And look, we're not necessarily unforgiving. I think Jonathan made a good point. Strive for perfection, right? But everyone knows that mistakes will be made, and we can be very forgiving of mistakes if you've really done a great, this is the one mistake you've made in the entire matter. You did everything you could do, but it just turned out that something was missed. But if that happens all the time, we look at it very differently. So nobody's perfect. Everybody understands it, but as close, you need to strive for it, and as close as you can come to it, that really is great. And we look at those lawyers, and we're amazed at how good a job you do, and that's really what you want us to be thinking about you.
So one of the things that I think, another thread that we've been talking about, and this translates into one of my pet peeves, is the scarcity of our time as in-house lawyers, right? Which is that our jobs, generally speaking, are to be spread across many, many matters, and we may or may not have a lot of time for any matter individually. So when we invest our time in something, when we get information or provide feedback on something, it's extremely frustrating. It's extremely frustrating to get back from your outside lawyer something that doesn't reflect the information or the feedback that you've given. It may be that the information's not on point or the feedback is wrong, but again, way better to acknowledge it and say, here's our advice, and we had previously talked about X, and you sent us this thing on whatever date, and we took that into account, but we still think that this advice is the right advice for the following reasons, right? Again, something that doesn't take a lot of time, but it shows that you're receiving the information or the advice or the feedback that your client's giving and taking it into account in the product that you're giving to them. In the absence of that, it's almost as though it's a one-way mirror, right? That you as the outside lawyer are just feeding things back to the client, and it doesn't matter what's coming back from them, which can be very frustrating in terms of having your client know that the time that he or she's investing in working on the matter is actually valuable.
And one thing I would add to that is it's often the case that I work on some matter, and maybe you're handling multiple things for me. So we got a couple things going on, and then something we dealt with something a month ago, and now it's come back in some fashion. Chances are I don't necessarily remember all the details of what happened a month ago. So it's really important for me when this new issue comes up that you do remember what happened. So yeah, we already looked for those records and we confirmed with so and so that they don't exist. Or yeah, we reached out to that person and we got this information. So that I'm not the one who's responsible for remembering that we did that, because I just may not, remember. So it's really important, I think, if, as Jonathan says, if I tell you information, that needs to, I don't want to repeat the same information. I don't want the same questions asked again. And then if we've sort of already taken care of some things, even if it's been a couple months, I'm wanting you to kind of bring all that forward. You should be the one who's sort of the repository of all that kind of, institutional knowledge.
So one of the other things, a lot of general stuff we've talked about here is in terms of giving me time to deal with things and no surprises. But to draw that together, don't force my priorities, right? One of the reasons to give lead time is so that I can look at the total mix of what's on my desk and figure out how I'm going to account for those things consistent with both my own time management but also the organizational needs. If there's a surprise or if there is insufficient lead time given an issue, what that's going to do is take my carefully constructed to-do list and toss it right in the garbage. It's very difficult to deal with that because, again, you may or may not know about the call that Zach's going to get from his head of sales who urgently needs his help. And if he doesn't have time to put your work in the priority queue where it needs to be, it's going to make it a lot more difficult for him. And the other piece of this is people may have priorities completely outside of work or demands on their time that are outside of work. Childcare needs, parental care needs, social visits, vacations, and you don't want to be the person who gave the brief to the client 2 days before it's due when the client was supposed to be out of the office, and then you're forcing them to give up something that may be important to them personally versus getting their work done.
Now we get to do that to you. Again, it's one of the things that's really unfair about this relationship, and I'll just for fun I'll call some of my outside lawyers on Friday afternoon. Hey, how you doing? Thinking that that's the Friday afternoon call. Means hey, I've got something I need on Monday. Often I just do that for fun and say, hey, you did a great job on that. So Jonathan, what about the role of sort of socializing with in-house lawyers for business development or client relations sort of purposes? How do you view that? Is that something you see as important? What's your take on it?
I think it's another situation where it might be best to know your audience, because I suspect that there are clients who really love to be taken out for drinks or lunch or breakfast or the performance of whatever.
Right.
And then there are clients at the other end of the spectrum. And I would put myself more towards the other end of the spectrum, which is to say...
Unless the tickets are really good.
Which is to say, it's really nice to like your outside lawyers, and that makes everything go better. But what you're really looking for is help. So even if I would every time choose the person who I don't particularly like,
right,
but is really effective, over the person who I like a lot but who keeps dropping the ball. So I think socialization is important to a point that you want to be liked, but it's not a substitute for doing the job well or for being prepared. And in terms of getting work, the most important thing is just being top of mind when the opportunity arises. So whether you took the person to lunch the day before, or whether it's just that you send them an email when you see that a new matter comes in, or that you wrote an article that happens to address the topic. There are lots of ways to be top of mind and to get business that don't involve socializing.
I agree. It's certainly nice to be invited to things, and even if we say no, we certainly appreciate that you thought of us when you had Lakers tickets or whatever it is. But I certainly agree with Jonathan that I'm going to look for the person I think is going to do the best job, not necessarily the person that I like hanging out with. I think socializing, certainly there are going to be organic opportunities to do that. You close a big transaction, or you settle a litigation, or you win a motion. That can lead to drinks or a dinner. That seems perfectly organic and natural. For having outside counsel, calling me up and, hey, you want to grab a beer? Maybe I do or maybe I don't, but maybe, I want to go home and spend time with my family, or, I have to go pick up, my wife or whatever it is. So I think, again, just the way to develop business really primarily needs to be showing how good you are at what you do. And then, as Jonathan said, if you see that, Fox got sued by so-and-so, you should have somebody in your a managing attorney's office watching the dockets, then you send a note to Jonathan, hey, I don't know if you've seen this complaint, think of me, etc. That's the best way to do it. Jonathan, what about, is there any advice that we can give associates in terms of how they can be, better prepared to serve in-house clients?
Yeah, I think that there's a lot that you can do to be better prepared when that matter comes in.
Mm-hmm.
Once the matter comes in and once you have been assigned to it, do some research on your own time, not necessarily case-specific work,
Mm-hmm.
but learn about the client's business. Learn generally about the context in which they operate. So if it's the entertainment industry and you're working for a movie studio, maybe you know what a movie studio is and does, and maybe you don't. So worth learning. Learn specifically about what the client's business is, and there's lots of public documents. If it's a public company, you can get
pull the K, pull the Q.
Yeah, pull the 10K or the 10Q from the
Yeah.
SEC filing, see what their big business is about and how big a part of their business this particular matter might affect.
Mm-hmm.
If they're not a public company, there may be still news articles about them or about their principals.
Mm-hmm.
Find out who their officers are, the key people, because it's pretty embarrassing when your client tells you on the phone that so-and-so said this, and you're sitting there not knowing who so-and-so is, and it turns out that so-and-so is the CEO.
Right.
So lots of things that you can do that help you be prepared and that basically start the conversation a little bit further along than it would be if you hadn't done that preparation work.
Yeah, another area I would mention is secondment. So if you do have the opportunity to go and work for a client for a month or a number of months, I think that's a great way to learn, certainly their business and the industry. It's also a great way to kind of turn the tables and to see how your client views you and how what it's like to be an in-house lawyer, if only for a couple months. I think that will really inform you. You will go back to the law firm becoming much better informed about how the company works and what the in-house lawyer's day is like and how you can be better. And I think you'll find a lot of the things we're telling you here today really will resonate. Another reason, of course, to do it is that it's a good path to getting hired as an in-house lawyer. A lot of times companies will try out associates in a secondment situation and then make them an offer. And even if it's not with that particular client, if you're going out and interviewing for an in-house position that comes available, you're certainly going to highlight on your resume that you spent 6 months seconded to Fox in their litigation group. And as an in-house lawyer, whenever I've seen that on someone's resume, I've thought that that's extremely valuable experience and certainly something that gives them a leg up over just somebody who's never been in-house in any role.
One of the other things we talked a little bit about, understanding the factual context in which a case arises, understanding the industry, understanding the client's business or what it's like to work in an in-house capacity. So we talked a little bit about understanding the factual and industry context in which a given matter arises. We talked about preparing yourself by understanding what it's like to be in-house either at the client specifically or at a client. But there's something else that anyone at a law firm can do at any time, which is identify the areas of law that are most relevant to the industries that you want to work in and learn about it and display that mastery by writing an article or giving a presentation. So if it's the entertainment industry, it makes sense to learn about intellectual property, right? Learn about copyright.
Go to those Copyright Society meetings.
Meet people, right?
Yeah.
And find a topic that interests you and learn everything there is to know about it. And then when that matter comes in that is relevant to that area, you're going to have a great sales pitch for why you should handle it, which is, I understand that this matter involves fair use. Here's an article I recently wrote on fair use that covers the most recent case law, and I'm not going to need any get up to speed time in terms of learning the law when you assign us to handle this matter. There's an old chestnut that there's no such thing as a stupid question. Do you think that's true in terms of things that associates might ask?
Unfortunately, no. I do think that there are stupid questions, and let me explain a little bit what I mean. I remember when I was at a law firm, being in a meeting, and it was actually on a transactional matter, and we had a very junior associate that was in a meeting that involved, the in-house lawyer. I think it might have been the general counsel, and I think another representative from the client, a couple partners. And it was about a financing transaction, and in the middle of this meeting, the associate sort of asking, well, what's a secured, party, or what's the indenture? I mean, part of this is we've said know your audience, don't kind of get ahead of yourself, but really you have to use your judgment. I mean, like everything in life, there's a bit of balance. So you're going to be, and you probably, I'm sure, have already been put in situations where you're the most junior person. This is your first time with an entertainment client, your first time handling a copyright matter, your first time on a big licensing deal. So you need to sort of, you're going to be in taking in information, listening mode, taking notes, right? Not just sitting there, not being productive. But that's not the situation where you want to ask a very basic question. Well, I don't understand what exclusivity means, or what's a holdback. Like, you may not know, but if you probably sit there and listen a little longer, or after that meeting, you can go and research this. You can figure it out for yourself. So I think you can embarrass yourself, and you can make yourself look like you don't know what you're doing by asking sort of quote unquote stupid questions in an environment where it's really not appropriate, and you just have to use your judgment there. I think that you're going to develop, as you get more senior, better radar for this. But when you're first starting out, it's that old Mark Twain, thing. It's better to be, quiet and thought a fool than to open your mouth and remove all doubt. So a little bit of this is when we go out to an outside firm and we're hiring you because you know your stuff. But not everyone at your firm knows everything, right? I mean, and there's the people who know the most, and there's you. You don't want to sort of remove that veneer of you're on the team of people who know everything, right? Think of it maybe that way, and you don't want to be the one who's asking a very basic, inappropriate question. That said, you also don't want to speak out of school and sort of say, oh, well, this is what you should do when you're really not sure. It's a little bit of a fine line, but I think I'm getting across the point that you just know your audience, be mindful that you are on a team of experts, and maybe you're not the expert on this particular issue, not yet. You don't want to be the one who's asking those kinds of questions in a context where it just will reflect poorly on you and your firm.
The way I think about a stupid question is, you should never ask a question that you could have had the answer to if you'd prepared adequately for the situation, which is to say the kinds of things that Zach raised. If you had done general research or general information gathering about the matter or the context in which it arises, or even had a conversation with the partner before you came in and asked the right questions, this is all information that you should have had. Right. And you don't want to display, along with not being one of the experts, you don't want to display a lack of preparedness, because when you have that big meeting, you're supposed to have done all the work that makes you ready to be there. And if you're asking a really basic question, what that signals to the client is not just you don't know the thing that you probably should know, but that you haven't taken the time to prepare and invest.
And that's much worse.
Right.
Well, great. So let's see, in terms of key takeaways and summary, Jonathan, what are some of the things that you would say, kind of boiling all this up into just a few kind of nuggets of advice? What are the kind of key things that people who are watching this program should learn?
Yeah, I think that the first and most basic thing is just avoid mistakes. And when you don't know something, own it, right? Know when you don't know something and communicate that. Secondarily, anticipate client needs and think broadly about the question asked. Don't just answer the narrow question, but think around the problem in the overall context in which it arises, and try to add value by answering questions around the specific task posed. Everything, plenty of lead time, no surprises. Convey mastery and do the little things that will allow your client to invest his or her confidence that the matter is being handled appropriately and that no detail would be left unaddressed. Know your audience. Know the level at which you need to communicate information, the best way to communicate the information, and how important the matter is to that individual client. And then finally, listen, absorb, respond, and challenge, right? Don't take for granted that everything you're hearing is right, but acknowledge that what you've heard and that it goes into the overall mix of the advice that you're giving.
So with that, thanks for joining us today.